I took them in the other room. We're back on stream, and Mr. Kussner, we will, over to you, I guess.
Thank you, Mr. Chair. The city's next reply witness is Ms. Anderson.
Hello, Ms. Anderson, you are still under oath from the last time. Welcome.
Thank you.
Good afternoon, Ms. Anderson.
Good afternoon.
Ms. Anderson, you'll recall when Mr. Minette was testifying. Actually, let me just back up a second. Just for the purposes of your reply evidence, can you indicate whether you were able to tune in to all of the proceedings from the time this hearing recommenced earlier this month until today?
Yes, through the virtual feed, I was able to attend and hear the evidence of the planners and witnesses for the other parties. Yes.
Thank you. So you'll recall when Mr. Minette was testifying, he confirmed that during the hiatus between the July hearing dates and September dates, you and he had an opportunity to meet, as had been prearranged, and had agreed on some further proposed modifications or refinements to both the Part 1 official plan policies and the proposed modifications to the secondary plan. You recall that?
Yes, that is correct.
And we heard some evidence from Mr. Minette himself on those further modifications or refinements. And I wanted now to get your evidence in respect to the same proposed modifications that he had discussed. So why don't we deal first with the proposed modifications to the Part 1 official plan. And just by reference, the document that's already been filed as an exhibit is Exhibit 34. And I understand you've provided an updated version to that exhibit that reflects the further modifications or refinements that you and Mr. Minette had discussed. Is that fair?
Yes, that's correct.
Okay, so with that, and Mr. Chair, this has already been circulated in advance to all the parties. So they have a copy of this, and I'll ask Mr. Kahar to hand up, or Mr. Crawford to hand up the revised red line version of Exhibit 34.
So we'll make that Exhibit 73, is that correct?
Thank you, Madam Chair.
I'm sorry, can I ask when this was circulated just so I can find it?
2 days ago?
I believe so, yes.
Sunday night, I believe.
Mr. Kussner, just remind me, what would you like to call this?
I think we can call it revised version of Exhibit 34, proposed modifications to Part 1 official plan.
Thank you.
So
are you able to put that on screen?
And unfortunately, I'm looking at my list and it is the one item that I do not have.
sorry, Mr. Chair. Mr. Chair, I am looking at my emails from Sunday and I am not seeing this, and it could be completely my fault, but is it possible to send it to me again? Well, I may not have received it.
Mr. Cherniak, it may be Saturday evening or Saturday morning.
Yeah, part of it was sent, or the entire package was sent on Saturday morning, and then Sunday morning is my recollection. I sent out an update to 2 of the documents because there was an error in one of them.
I see. So was it one of the updated versions?
So you got to go back to the Saturday email to get all of the documents, and then the Sunday email's got one of the documents that actually has a correction. The other is just, we forgot to include the track changes for something, so.
I'm sorry.
So
I see the emails, but it's not clear which one is the changes that relate to Mr. Minette specifically. There's a number of attachments that are other things, right?
Right, so you've got to look at, in this circumstance, Appendix C, because this was all part of that.
Okay.
Right, so Appendix C is the final proposed modifications Part 1 plan. There's a clean version and a track changes version of that as well. It's included in the email. And I think we're going to the clean version.
Okay, I found that. Thank you.
Okay.
Mr. Kagan, have you marked the clean version as Exhibit 73? I can't hear you.
I think the version,
I just named it revised version of Exhibit 34 proposed mods
Okay.
to Part 1 OP. I'm like, we all have to just have in our files what Exhibit 73 is. If you want me to say whether it's red
No,
line-
no, I'm just assuming it's just the clean version, not the track change version.
Yes, it looks like the clean version.
Thank you.
so Ms. Anderson, perhaps you could just walk us through the further modifications that we see reflected in this exhibit.
Yes, Mr. Kustner, this Exhibit 73 is in essence Exhibit 34, save and except for one further change that you would find on the second page, where it references modify policy 4.4.1 sub 7 as follows. And the LPAT members may recall that this was a subject of discussion in relation to the requirements for a concept plan to be provided prior to approval of the secondary plan, and the logistics of such that this LPAT may in fact make a decision making this particular policy not in force and effect. But then again, we are entering into a phase 2 hearing where there may be parts of the plan that are not in full approval. And the thought was to simplify this in relation to whether it's a concept plan for quadrants or blocks because of the reference in the Part 1 plan. Mr. Minette and I reviewed this and agreed that the simpler approach to this policy as a modification would be to take out all of the language after the fourth sentence. So rather than referencing what is included right now for areas identified as a development block by the town, and you won't see that in the clean version, but that is what is in the current Part 1 policy. It was our intention to take that out and also remove the additional wording, which was for clarification, that was a result of the discussions and settlement with TSMJC. So the policy now is simplified. It still retains the requirement for the concept plan to be prepared prior to the approval of the secondary plan.
Thank you. And if we can just clarify for the record, there also appear to be a number of minor or typographical changes reflected in Exhibit 73. And if we can just confirm those for the record, the first one appears to be in the very first policy, 3.1.3 subsection 5, which was originally proposed to be adopted without any further modifications. But we now see a change in the second line of the policy to reflect the fact that it's now the city of Richmond Hill as opposed to the town.
That's correct.
Okay. And then there appears to be another one on the back page where it refers to, in policy 4.4.1 subsection 9, it now reads the tallest building shall be directed as opposed to direct
That's
in
correct.
subsection D.
That's correct.
And perhaps you can confirm, I think that's all of the other minor typographical corrections that have been picked up in this document.
Actually, Mr. Kustner, there is one further on the first page, and that was caught by Mr. Manette, and it's in 4.4.1 sub 6 sub A. And you'll note that the additional wording, or sorry, the existing wording references the density of a development block within a KDA shall be a minimum of 2.5 FSI and a maximum of 3. And the term FSI has been added to that section.
In response to requests from various parties, I understand that you also prepared a consolidated version of the proposed modifications to the secondary plan, which the city is proposing, but which also includes the subsequent modifications that have been the subject of agreements with various other parties. Is that correct?
That's correct.
Okay. And you've provided that to me and Mr. Kahar, and we provided copies to my friends.
And I
I
do
think-
have that. I can
Okay.
share my screen with that.
And I think for the purposes of this exercise, Mr. Chair, it might be of assistance if we handed out the red line versions of that document to show the track changes.
Mr. Kustner, can you confirm, is that Appendix A with track changes?
Yes, it is.
Okay.
This is to be Exhibit 74. What do we call it, Mr. Kustner? Again,
City's proposed revised secondary plan modifications, September 18th, 2020.
thank you.
So Ms. Anderson, perhaps you could just walk us through the relevant changes here that you wanted to bring to the tribunal's attention.
Yes, Mr. Kustner, this document provides a track change version, and the changes that have been made to the document are shown as underlined and in red. So those are changes that are being highlighted, as well as strike throughs where wording in a policy has been removed. And the additional notification in this version is that anything highlighted in yellow is intended to be a policy deferred to the phase 2 hearing with one anomaly that I will speak to, and also I'll speak to the schedules. But this document is a result of the amendments that were proposed through Exhibit 35, which was through the settlement with TSMJC, and then further changes as was proposed through the evidence that the LPAT heard from Mr. Manette, which was based again on discussions Mr. Manette and I had in relation to agreed upon areas of further modification to the plan. So there are some, what I would reference as some minor clarifications and corrections that you find on page 1, and I'm hoping you can see my screen. I'm sharing my screen here. Just going to move to this, move my Zoom up. Oops. There we go. And you'll see in the first section of the plan that deals with the purpose, there is a correction to the term settlement area in capitals. And then further down on that page, you'll see the addition of the word in the third sentence that refers to the KDA being transformed into a cohesive, complete community. So the addition of the word complete. And then there are no further changes or references until we come to section 12.2.1. And I'll just forward on the screen. And this is under the section mix of uses. And there are two proposed changes in this section, and these came through the discussions between Mr. Manette and myself. And this is the addition in subsection 4 that relates to development on lands with existing non-residential uses such as retail, office, community, or commercial uses. And the words including drive-through facilities has been added to reference the existing drive-through facilities that exist within the KDA. And a new subsection 7 has been added. And this reads that redevelopment within each of the quadrants within the KDA for a mix of uses will consider the variations of the existing conditions in its respective quadrant and the need to phase development accordingly. And this was an added policy that both Mr. Manette and I felt was appropriate to provide some context to the mix of use section, which recognizes that in some of the quadrants, there are existing commercial uses and there are existing conditions which would relate to a different phasing of development as would perhaps be more appropriate on the greenfield areas on the west side of the KDA. So this was to recognize that each of the quadrants is somewhat different in its context and that redevelopment within those areas for a mix of uses would be phased accordingly and based on context. So it reinforces that concept of the difference in conditions. And Mr. Chairman, I believe that's an appropriate addition to include within the secondary plan to give direction. And the next change that was proposed is actually the change that I would refer to as a bit of an anomaly. As you will see, there are changes to the text which have been agreed to by TSMJC as part of the settlement. However, this particular policy based on other parties would be deferred to phase 2 on a site-specific basis. And so this is the section of the plan that's dealing with density. And you may recall in evidence, I indicated that there are certain properties or parcels that actually straddle more than one density allocated area in the schedule. And so this policy is intended to provide some guidance with respect to those types of policies where the property boundary spans more than one density category. And this policy speaks to density permissions will be calculated based on the land area present within each category on a prorated basis in accordance with the overall land area of the property, recognizing that a property may have a density less than and or greater than the density applicable to each of the land areas. So this was intended to provide some clarity in relation to those specific properties that do span more than one density to give that prorated allocation of density. This is very similar to what is provided for in the language of the zoning bylaw as well for consistency. And one further additional note in this section, just at the bottom, you will note that in order to ensure, and this is subsection 5 of 12.2.3, and it indicates in order to ensure that all development within the KDA is transit supportive, new development shall demonstrate that it can support a minimum of 200 residents and jobs per hectare for the development site. And this was added in as there is also reference in other sections to meeting minimum density targets, that new development is a term provided for redevelopment that would not include in-term development or the building out of a site for those in-term uses, which are also recognized in the zoning bylaw. So it was felt that the addition of this word back into the plan provides some clarity. And finally, related to that notion of new development versus existing development and the expansion of existing uses was the added language, and this is to section 12.2.3, subsection 5 as well, that goes on to state, and this is in reference to development on the site, it states, this generally translates to a minimum FSI of 1.5 for the site. It says this policy shall not preclude the redevelopment expansion of existing uses within the KDA as permitted through the implementing zoning bylaw. And so again, clarification that the redevelopment or expansion of existing unit uses would not be required to meet the minimum 200 jobs and persons per hectare, as well as the minimum FSI. And then the balance of these next few sections of the plan remain without further modifications until we come to section 12.2.6 that relates to housing. And subsection 5 previously referred to new rental accommodation will be promoted. And after discussions and review of the information in the witness statement provided by Mr. Minette and our further discussions, and also further discussions with the city staff, it was felt that this needed to be clarified to make it clear that it's new purpose-built rental housing that should be provided for in this section, and added wording to be encouraged and promoted to address rental housing needs was important. And this was making a distinction between purpose-built rental housing and rental accommodation, which could be private condominium units being provided for rent as opposed to purpose-built rental. And so this clarification, in my opinion, was important to provide in the plan to ensure that purpose-built rental housing was specifically identified and provided for in the housing section of the policies. And further on this page under section 12.3, there is in essence just a clarification or a reference under 12.3 subsection 2. And this is in relation to the reference to providing private urban plazas that are publicly accessible. And we added in, after discussion, the reference to the term POPs, which is commonly used. Often in planning, we're using acronyms that the public may not be familiar with in terms of park space that is privately owned but publicly accessible. So for clarity, we've added in the reference to that term. And Mr. Chairman, you will note that on the following section of the plan, the Greenway System 12.3.1, this entire section is highlighted in yellow to reflect its deferral for consideration to phase 2. And there are no further modifications to the plan until we come to the section dealing with transit under connectivity, which is 12.4.2. It's actually not until we get to the bottom of that section, gone a little bit too far, that we see the revised policies as they relate to the Bernard bus terminal. And these modifications are reflective of those that were provided to the LPAT through Exhibit 35, and through which evidence was provided by myself and other planners in support of these modifications.
Just while we're on that policy, Ms. Anderson, we heard evidence from Mr. Minette with respect to his proposed modifications to this policy as it was agreed upon between the city and TSMJC and the region and other parties. Did any of the evidence you heard from Mr. Minette cause you to revisit your opinions with respect to the merits of this proposed modification?
No, it did not. And perhaps it would be appropriate here to just reinforce the importance of providing the wording as is provided, and that is development within the KDA shall support the potential redevelopment of the bus terminal. And I believe
Mr. Chair, sorry, this is not my issue, but out of principle, I don't think reply evidence is supposed to reinforce the direct evidence that we heard when she was first on the stand.
Mr. Chair, that wasn't the intention. The evidence that she was about to provide was focused entirely on the evidence we heard orally from Mr. Minette with respect to his proposed modifications to this policy, which this witness did not have an opportunity to address as part of her evidence in chief.
But her answer was that it doesn't change her opinion. Isn't that the answer?
No, it's not, because she was about to focus in on the specific changes that she hasn't had a chance to address previously.
Hadn't quite finished, Mr. Cherniak.
Sorry
Please
if
proceed.
Mr. Minette had indicated in his opinion that the wording should stay to be specific to the southeast quadrant for two reasons. One was that no study had been done or no necessity was provided for the consideration of the terminal in another location. And also that in determining another location, there needs to be a policy, a study prior to putting a specific reference to the KDA-wide consideration. And my only 2 points on that were that the reference to this policy as it was approved by council in the November 2017 version was to the KDA-wide reference. So in the November policy, and I can turn to that, or I will turn to that if required, but the language was such that the policies reference development within the KDA to support the Bernard bus terminal, and it was not quadrant specific. And so consideration in formulating those policies was undertaken through that particular plan that was adopted by council. I would also note that in terms of consideration for flexibility to ensure that the bus terminal can accommodate future growth and may need expansion or potential relocation, there are other policies in both the Part 1 plan as well as not the Part 1 plan, but in terms of the growth plan generally and the regional plan that talk about the importance of securing lands for transit, and that includes terminal locations. And so for those reasons, I believe these modifications are appropriate to maintain the consideration for the future expansion and relocation, and also providing clarity as to how that process would go forward in terms of the environmental assessment.
And in terms of any of the other proposed modifications or deletions to this policy as recommended by Mr. Minette in his evidence, was there anything else you wanted to reply to?
No, Mr. Chairman, I believe the amended language here provides clarification as to the future redevelopment, the potential for the process, and how that would be considered in terms of the owners of lands within the KDA.
Thank you. So what was the next policy you wanted to take us to in Exhibit 74?
I believe the next set of changes are in relation to the collector and local streets. And these were the series of amendments and changes that were provided in Exhibit 35. And these are under section 12.4.42. And these were a series of modifications to the plan to, as was provided previously in evidence and was also further noted by the other planners, providing for clarification as well as flexibility in relation to collector and local streets, both in terms of clarifying the policies in relation to the schedule, and I'll speak to the changes to the schedule in a moment, but also providing clarification for the location alignment and layout and widths of street may be different from what is shown conceptually to allow for context-specific considerations, so long as the street network, that finer grain network, is maintained. And so these modifications, Mr. Chairman, provide for that. In addition, there were policies, and this is on the next page under sub 7, that were added, and these are in relation to the use of stratified public street or private street with public access. Provided that, and there's a series of requirements here, one of which is maintaining that there be a council-approved policy permitting the use of a stratified public street or private street for such purpose. And then it goes on to identify where it can be demonstrated that the provision of a conventional public street would adversely affect the developability of a site, and goes on to also state that it protects and does not impede the city's ability to operate, service, maintain, and replace infrastructure services and utilities in the stratified public or private street. And finally, that it maintains the functionality and characteristics listed in section 12.4421 and is designed in accordance with section 12.4425. And these policies are important to be maintained. And I know in the evidence from Mr. Minette that his planning opinion respectfully was that the stratification should be generalized and should be provided for in the plan, and that there is not a need for a council-approved policy for stratification in order to convey the use of stratification in the policies. And I would respectfully disagree that I do think stratification can be complex, and there are various elements of how and where and why stratification is to be used. And I do think it's appropriate to reference that it is available, but it should be through council consideration and approval as part of the implementation of the plan. And so it's my opinion that these policies should remain as modified and not be further amended or removed as was recommended through the evidence of Mr. Minette.
Just on that same point, Ms. Anderson, in his evidence, Mr. Minette also suggested that the criteria set out in this proposed policy A through D should be deleted in their entirety. Do you have any opinion by way of reply to that evidence?
Yes, Mr. Kustner, to the LPAT members, I think it's important to establish some basic criteria which may be inclusive in the council approved policy, and as such should reinforce the importance of, again, providing for private versus public street, as well as stratification of such a street. And so referencing back to some of the policies about functionality of streets and requirements for streets, I think is important in any consideration, in addition to council approved policy, which would also be relevant, not just to the KDA, but to other areas of intensification.
And similarly, in his oral evidence, Mr. Minette opined that policy 8 that we see in the next section should be deleted in its entirety. Do you have any opinion by way of reply to that evidence?
Yes, the policy that Mr. Minette is seeking to delete is one in which the policy itself is speaking to the appropriateness of a stratified public or private street. And it further refers to planning phases subject to requirements of 12.4427. And going to, again, back up to that section in the plan, I think it's important to connect any phase of development in stratification such that it doesn't preclude, for instance, with a phase development, if you're using stratification, there's consideration of that stratification through the full build out or phases of a particular development. So I think it's important to recognize that where there is phasing, that those requirements set out in section 7 should be considered from the beginning so as not to preclude any particular phase from further development. Or sorry,
And-
further stratification.
Thank you. And where did you want to take us to next in terms of the proposed modifications?
I believe the next few sections, if we go down, I'm hoping I'm not missing any. I know there is a reference deferral to phase 2 as it relates to the encroachment policies, which are found on the next page under 12.47. And then in the implementation policies, the majority of the final modifications are with respect to the policies that relate to the holding bylaw. And this relates to the addition of the reference to the 10,400 residents and jobs. And this was seen as appropriate clarification in the policy as it's referenced in the chart. There's also notification in the section of some areas that are deferred to phase 2, and these are those that relate to the provision of the non-residential GFA requirements. And then in the chart itself, there were some additional modifications that speak to defining modal splits, as well as the region's projects and some clarification with footnotes, and also the notation that the regional projects listed above and with the constructed under construction being struck from the policy and being added that be included in the region of York capital plan. So these modifications are seeking some clarification with some additional references. And also, and these relate to the footnotes that are referred to in the table. And again, these were provided through Exhibit 35 and the evidence you heard from both the planning and transportation witnesses. Also in this section, again, the further deferral to phase 2 of the holding provisions as it relates to the non-residential gross floor area requirements. And finally, on this section, there is in the implementation section references to the subdivision of land. And again, these were modifications as discussed with TSMJC, and it was agreed that these modifications provide some clarification to the plan as it relates to a draft plan of subdivision process. And finally, as it relates to the schedules on the plan, just hopefully these are attached. And I'm not sure if I can zoom in, but on each of the schedules, there is, a notation that has been added for clarity. And it states, note, lands designated greenway system in the Northeast quadrant remain under appeal and are deferred to the phase 2 hearing. And that is provided on each of the schedules, as that designation is shown on each of the schedules. And finally, on Schedule 4, there actually are some modifications, and to assist the board, we've provided those modifications with some highlights on on this plan, and it actually helps clarify some of the elements on this plan that Mr. Manette actually noted were on the schedule, but were not in the legend. So most of these are for clarification. And if I just scroll down to the bottom, you will see that previously the pink dot, it's a little bit difficult to see. Let's try it, zoom in a little bit. Oops, way too much. My apologies. You will note that the pink dots refer to bus rapid way transit station, and that notation was previously not on the schedule, as Mr. Manette had noted. You will also note that in the Exhibit 35, there had been some wording that recommended that where planned collector streets were shown, that be shown as planned collector / local streets, because it could reference both collector and local. And finally, very difficult to see, but in the little note section at the bottom of the schedule, there's a little bit of highlighting there, and really it's intended to add the wording basically that states as shown conceptually on the plan.
So does that complete the proposed modifications as shown on Exhibit 74?
Yes, that's correct.
Okay, thank you. And Ms. Anderson, you've also provided us with a updated version of the proposed KDA zoning bylaw, which incorporates all of these sections that have been agreed as amongst some of the parties, at least, to be deferred to the Phase 2 hearing.
That's correct.
And Mr. Chair, Madam Chair, I think it would be of assistance for the record to file this as the next exhibit. And before anyone gets too exercised about it, I can confirm for the record that this document is unchanged from the version of the zoning bylaw that was endorsed by Council in May of 2020. The only change reflected on this document that we're about to file is highlighting to reflect the sections that have been deferred to the Phase 2 hearing.
It'd be 75. How can we express it?
Propose KDA zoning bylaw with deferred sections, September 18, 2020.
Sorry, Mr. Kussner, it's Mr. Kagan here. What was Exhibit 74? I must have missed it. I have 73 as revised version of Exhibit 34. And then what was 74?
I can't remember exactly what we
I
agreed.
have it. I have
Oh,
it. The
great.
city's proposed revised secondary plan modifications, September 2020.
Thank you. Sorry about that.
So Ms. Anderson, was there anything specific you wanted to take us to in Exhibit 75 with respect to the deferred zoning bylaw provisions?
Mr. Kussner, just to reiterate that the notation on this bylaw is to identify the deferred sections, and those again are highlighted in yellow. And then a further notation to indicate that the entire zoning bylaw for the eastern quadrants of the KDA, save and except the Richmond retirement lands at 70 Bernard, are deferred to Phase 2. And so going through this document, there are deferred sections for the entire KDA, and they mostly relate to the holding provision, which I think I've just gone past. Maybe I haven't. Yes, I have. Yes. Yes, you'll see the sections here. Interim development in its entirety. My apologies. And also certain sections of the holding provisions. And so those have been deferred in their entirety. And finally, the only other note I would make for the LPAT's assistance is that we have applied a similar notation on each of the schedules A through E of the zoning bylaw. I'll just bring an example of one, which is very similar to the secondary plan. Whoops. And that is to show that the land zoned open space in the northeast quadrant remain under appeal and are deferred to the phase 2 hearing. And that applies to each of the schedules as the zone appears.
Okay. And with that, Ms. Anderson, perhaps I could just ask you to provide your overall planning opinion with respect to exhibits 73, 74, and 75 with the modifications and deferrals that are shown in those exhibits.
Yes, Mr. Kussner, based on these further modifications, it continues to be my opinion that the modified plan with these additional changes are consistent with provincial policy, conform to provincial policy and regional policy, and represent good planning in the public interest and should be considered for approval by the LPAT.
Thank you, Ms. Anderson. Ms. Anderson, you'll recall when Mr. Manette was giving his oral evidence, he testified at some length and beyond, well beyond what was in his one witness statement, respecting his opinions on the appropriate structure of the secondary plan, the wording of certain policies in the secondary plan. And I'm wondering if you can provide your opinion in reply to the evidence we heard from him in his oral testimony.
Yes, through my listening to and assessment of Mr. Manette's evidence, he had noted through both his oral evidence and had identified when he was presenting that there were a number of policies in the secondary plan that he felt should be further modified as they were not needed. And also a notation that the plan did not extend, I think what he referred to as a level of flexibility to accommodate certain properties and site-specific constraints. And it's my opinion that the current formulation of policies is appropriate and to reinforce that the plan is a comprehensive plan. And so there are a number of policies that direct future development through the character areas as they're defined. There's clear notation of the types of density and direction for where certain types of density should be located, being the tallest buildings towards Yonge Street. And there's also clear policies that are provided which speak to the built form type of controls for development that are intended to encourage transit supportive development. And in fact, the built form approach itself, I would reiterate, is one of the most flexible ways in which to accommodate conditions to ensure appropriate transition of height and compatibility. And all of those policies together, including even the transportation network, which by virtue of the considerations for public and private, both in terms of streets, which is now modified in the plan, as well as the opportunity for both public parks as well as publicly accessible private parks in the form of urban plazas. All of those elements of the plan knit together to provide overall goals and objectives as is set out in the plan. And it remains my opinion, which is somewhat contrary to the evidence of Mr. Manette, that the secondary plan itself should really set direction and policies and objectives for the plan as a whole. And that would provide for development to fit within those policies and objectives, as opposed to providing exceptions for each of the specific contexts or areas and alter those in each of the areas to allow a proposed development to fit within the plan. And respectfully, I would disagree with Mr. Manette that the plan should allow for any and all conceptual plans to move forward without any consideration for changes to the policies. And I wanted to reiterate on that point as well for the LPAT that if a development concept comes forward that doesn't quite fit, and it's felt that it cannot be modified based on a particular condition or constraint, it doesn't deny the opportunity, firstly, to be addressed in phase 2 of the hearing, which we know can accommodate some of those changes with appropriate evidence being brought forward. And the entire zoning bylaw, which would implement certain aspects of development and unique conditions, remains under appeal on the east side. So considerations for site-specific context elements can still be considered, again, with appropriate justification and evidence. And certainly, as the plan goes forward, there's an opportunity to consider amendments and changes as conditions change. It's the nature of the Planning Act allowing applications at a certain point in time to come forward.
You recall when Mr. Manette was giving his oral evidence, it was his opinion that the planning horizon that we should be guided by for purposes of this secondary plan exercise was 2031. You recall that evidence?
I do.
And do you have any evidence by way of reply to what we heard from Mr. Manette in his oral testimony on that point?
So in relation to the planning horizon, technically the secondary plan is within the Part 1 official plan's 2031 planning horizon as it's nested under that plan. However, it's been noted through evidence that the build out of the secondary plan will occur beyond 2031. And in my opinion, that doesn't warrant the plan to be irrelevant in 10 years. It may need to be updated as all plans do, but the foundation of the secondary plan in terms of its policies and objectives can remain in place to support the vision and objectives. More importantly, I think we note now that as the new amendment to the growth plan is identified, we're moving towards planning now to 2051. And so it would be short-sighted in any event to suggest that 2031 should be a time frame within which the plan would have to be fully reconsidered. In many cases, plans that have been put in a time horizon that is not aligned with a particular future growth plan or policy that comes forward can be amended and updated through a scoped re-examination or review. And that's common to ensure that the plans do remain current. And so I do not share the opinion that the plan would be irrelevant after 2031. I think it would remain in terms of its foundation, very much relevant going forward.
Thank you. Ms. Anderson, you'll recall when Mr. Cherniak was cross-examining Mr. Patrick Lee yesterday, he put to him the proposition that the proposed holding bylaw regime should set out a maximum number of jobs and residents. And similarly, you'll recall when Mr. Cherniak was examining Mr. John Lee yesterday afternoon, or I'm sorry, this morning, I think in re-examination, he put to him, or he elicited from Mr. Lee his concerns when you get to the highest threshold under the holding bylaw regime, concerns regarding additional population that could be achieved once you get to that level. And I'd like you, if you could, to provide your evidence in reply to the oral evidence that we heard from those two witnesses.
Yes, Mr. Chairman, in relation to the holding bylaw and the policies that relate to the holding bylaw with the charts that illustrate the thresholds and the requirements to move forward, I wanted to clarify 3 matters in relation to this idea of having a maximum threshold within the plan. Certainly, I think it's clear, and I did hear this through Mr. Patrick Lee's evidence that the holding, the policies related to the holding bylaw are referenced in the bylaw itself. So the bylaw itself, and I'm not sure I need to bring it up, but the section in the zoning bylaw that deals with holding provisions makes reference back to where a zone or symbol is provided, the holding provision pursuant to section 36 of the Planning Act and the City of Richmond Hill official plan as amended, which refers back to the secondary plan. And so the policies in the Part 1 plan, as well as the policies in this secondary plan, as approved, would require consideration in addition to these zoning provisions. And I think in terms of any concern or doubt that there are no numbers in the zoning bylaw, certainly the numbers and the thresholds are appropriately provided for in the policies that are referenced in the zoning bylaw. So there's a direct link. And I just wanted to reinforce that section is in the zoning bylaw, providing that link to the required provisions of the Planning Act, as well as the policies of the official plan. And then one other point I wanted to note, and this, I went back and I looked at the numbers themselves, and I thought it was interesting, and we heard some evidence on this, that the actual numbers that are in the policies in terms of the chart for when you get to a certain level, what the requirements are. When you look at the HDR report, the requirements that they set out for a certain threshold in terms of jobs and persons was actually higher than what ended up being implemented in the plan. And so they had taken a more, the city has taken a more conservative approach in putting in what I would.
Sorry, Mr. Chair. I think the first half of that answer was fair. The second half seems to be introducing new issues, and they're not in response to either of Mr. Lee's.
I would disagree with that, Mr. Chair. I think it's directly responsive. The concern expressed by Mr. Lee was in relation to additional population beyond the thresholds that are shown in the holding bylaw. And I believe that's precisely what the witness has addressed and it was about to continue addressing through her next point.
What I heard was that she was raising differences between the HDR report and the secondary plan that existed when she originally gave her evidence, and I don't see the connection.
With your permission, Mr. Chair, I think there is a direct nexus. It's directly addressing the concern about additional population. And I think that's squarely what the point that we're about to hear from the witness is about to address.
Okay with that? Sorry? Yep. Go ahead.
So if I could perhaps to make the point, share my screen. And what I'm bringing up is, whoops, let me just do that again. What I'm bringing up is a copy of page, I think it's page 156, and it's found at volume 8, tab 39 of the HDR report. Here it is here. And again, my reference to this is that in listening to the information that was provided, there was a concern being raised that the actual populations that would be accommodated were much higher than what was being provided in the holding policies. And if we look to the HDR report itself, you will note that where they reference the, for 2041, where they reference 4.0 FSI in this first line, let's close this here, you will see that they say, which is up to 14,150 residents and jobs combined. In HDR's report, they're referring to the modal splits of the 30% and then the 30%, 20%. And then they're also referring to the 2020 year, a 10-year capital program and Bathurst widening. Whereas in the secondary plan, that threshold is for those requirements is actually lower, and it's at the 12,650 combined, which according to the HDR report is at the 3.6 FSI. So in hearing the evidence, the concern was that there was much more population and these weren't being appropriately applied, when in fact the HDR report recognizes that the modal splits and the requirements for capital improvements could be made at a much higher level. And in fact, the city has implemented that threshold, or that gateway, I'll call it, at a much lower threshold to ensure appropriate consideration before that development goes forward. And I would add to that that the threshold at in the city's plan, and this is at the 10,400 residents and jobs, that's essentially what I would call, in terms of a threshold, it's sort of I call it a stop sign. It's an alert. It says, wait, if an applicant is applying and the city is monitoring and they know that a particular development will meet that threshold or surpass that threshold, they must ensure that all the requirements of the holding provisions are met and that all of the required studies have been completed and assessed by the city before any of that development can proceed. And the other point I think that's important to remember is that that does not allow the next owner or landowner developer to come forward and go with the coattails of the one that surpassed. They too are subject to all of those studies and requirements going forward. So this stop sign, in essence, creates a situation where, as you're coming forward to that threshold or that capacity, appropriate consideration of these policies must be considered for each development, both in terms of the policies in the official plan and the provisions in the zoning bylaw. And just to circle back, for those reasons alone, it's neither required nor appropriate to put in place a maximum above which no further development can occur because of the safeguards and that threshold stop that's in place with these policies. In fact, in my opinion, I would perhaps go further and say that a maximum would be very challenging to implement and would not allow for the response to housing need and market that policy should provide for.
Thank you. Ms. Anderson, you'll recall when Mr. Minette was giving his oral evidence, he went on at some length about his concerns regarding the need for the secondary plan to provide a clear direction, to provide certainty, and in particular, not to have policies that contemplate future contingencies or are based on future studies. Do you have any opinions by way of reply to what we heard from Mr. Minette in his oral evidence?
Yes, Mr. Chairman, I had heard from Mr. Minette that he raised concerns with some of the language in the policies, identifying that the plan did not need to, I'll refer to it as protect for or provide for certain elements, specifically in relation to the potential signalized intersection had come up. And Mr. Minette had provided quite a bit of evidence in relation to that. And I would only indicate that it's my opinion that it's appropriate for the policies as they're formulated to identify where they are mandatory or required, and using language such as shall, and also identifying where there is some discretion or flexibility, using the word should, encourage, or may. And in fact, this secondary plan does just that. It identifies for both the short term and the long term with eventual build out using that type of language to provide for certainty. And I wanted to stress that I don't believe there's any downside to providing for the idea of future possibilities and to protect for those possibilities. Planning itself is planning for future contingencies, and you need to balance that certainty with the flexibility. And determine the risks of not providing such policies. And that is what, in my opinion, the KDA secondary plan does. It identifies those areas for future consideration and it protects for them appropriately. And specifically, the LPAT heard evidence that the potential signalized intersection should not be shown on the schedule and should not be included in the policy as it's not needed or required, and there's no warrant. And in any event, the region could assess a development application and require that intersection without those policies in place. But it's my opinion that it's appropriate to provide for that possible location, regardless of the region being permitted to pursue that through the development process, because it adds certainty and it minimizes risk to those who are looking at the plan to determine if that is a future possibility. And it still allows within the context of the plan for that type of consideration to be made. And I think it's important for the policies to include for future contingencies to, again, reduce risks and allow for future consideration of the infrastructure or particular elements of the plan that may be needed in the future. And I would also add that, in fact, the road network itself is identifying sort of the longer term road network and securing for those requirements in the future. And the amendments to the plan or the modifications to the plan are adding the flexibility that those can be considered for private versus public through the process. So this is, I think, in relation to not including policies to protect for future contingencies or possibilities. It's my opinion. I think it's appropriate to provide those policies and appropriate specifically as it relates to transportation infrastructure.
Thank you. Ms. Anderson, you'll recall in his oral evidence, Mr. Minette went on at some length and beyond what was in his one witness statement with regard to his concerns about the requirements for a secondary plan under section 5.5.1 of the Part 1 official plan and whether or not those requirements had been met. Do you have any opinions by way of reply on the evidence we heard from Mr. Minette in his oral testimony on those points?
Yes, Mr. Chairman, there was considerable evidence provided that there's a section in Part 1 of the official plan that sets out a list of requirements for the secondary plan and that they had not been met. And I wanted to speak to those in sort of two contexts. One was that this idea that a development concept had not been provided. And I just wanted to note that in the Part 1 plan itself, and if I can share the screen. And just very quickly, just to go to this section. The section reference was section 5.5.1. Oh, I apologize. Yes, correct. Thank you, Mr. Streisfeld. And this is the section dealing with the secondary plan. I'll just increase this a little bit here. And this was the list of requirements that new secondary plans shall include a minimum information and policies respecting the following. And Mr. Minette provided quite a lot of evidence around this idea that the proposed development concept for the secondary plan area was not provided. And I would reiterate that the secondary plan does provide for the development concept, as I had indicated through the vision, the objectives, the principles in setting out a descriptive narrative as to what that development concept is, as well as providing for figures and photographs to illustrate that development concept. But the distinction I wanted to provide for the LPAT is the idea that this development concept as provided in the Part 1 plan is in fact a plan. And if I can take the members to an earlier section, which is 5.2. Sorry, one later section. The Part 1 plan makes quite a distinction between development concept and the term concept plan. And I would note that in section 5.2 of the plan, which is referring to tertiary plans, concept plans, it's actually identifying a level of detail in a plan that's required, that's often referred to as a master plan. But the Part 1 plan is making a distinction of when a concept plan, as Mr. Minette was referring to, is required and can be utilized to assist with development. And so I wanted to raise this in reply to reinforce that the secondary plan does provide, again, for a development concept in the narrative and the images that are provided. And clearly a concept plan is something that is distinctive from a development concept and something that would require much more detail and would likely be provided through a tertiary plan. And the only other note I would make is that to have a concept plan for an entire secondary plan area, in my opinion, would not be appropriate. We have information from the city with respect to a demonstration plan, and in fact, that is appropriate to show how development can be deployed and confirm that the built form as it's proposed in the policies would be feasible and what that could look like under the different scenarios. So again, I wanted to make the distinction that those elements of requirements for a secondary plan have been met, including the requirement for the development concept.
Thank you. Ms. Anderson, you'll recall when I was cross-examining Mr. Minette in relation to his opinion about the importance of minimizing the cost of housing within the secondary plan. I put to him the proposition that while minimizing housing costs is an important objective, it had to be balanced against other important policy objectives. And to summarize, I think Mr. Minette generally agreed with that, but with some qualifications. And I'm wondering in your reply whether you can address the evidence he gave in response to my cross-examination on that point.
Yes, Mr. Chairman, there was quite a lot of evidence that was stated in relation to the plan not providing for the requirements in relation to minimizing the cost of housing. And I would note that, again, the policies cumulatively all provide for intensification within the area with a form and a range of housing types with the objective of providing for a full range and a supply of housing as part of a complete community. But in considering the full range of housing, it has to be considered with other policy objectives so that it can be balanced. And I would note that while the plan, in my opinion, does provide for a number of policies, including affordable housing policies, but policies that direct for more compact forms of housing, more cost-efficient forms of housing, it's through the implementation of the plan predominantly that the costs of housing are minimized. And that would include through the zoning provisions and how the zoning allows for certain forms of housing to be created, again, compact, efficient, utilization, optimal utilization of land, as well as site plans and other design elements. So all of those things combined, including parking, are through the implementation of the zoning bylaw and add to the minimization of those costs. I would also say that what perhaps has not been referenced enough is in the secondary plan, there is a policy in section, I think it's 12.5.1, and this is in the implementation section, that specifically references other tools that are available that are required to be in the plan to be used. But certainly in terms of a community improvement plan and other incentive programs under such a plan, such as reductions to application fees or development charges related to a specific type of housing and minimizing the cost of housing. Those are commonly used now to incentivize affordable housing or rental housing projects. And certainly as part of the secondary plan, those policies are in place and can be implemented going forward. So it would be my opinion that the plan, through its general policies as well as implementation tools, which are set out in that section, including community improvement plans, can and should be used to continue to minimize the costs of implementing needed housing supply.
Can you hear me now? You recall when Mr. Cherniak was leading evidence from Mr. John Lee, he elicited opinions from Mr. Lee on a number of points relating to heights and densities in the KDA. One was the opinion that the overall FSI should be reduced to, I believe it was 2.99, because among other things, smaller average unit sizes should be used in the assumptions. And another was that the height should be capped at a maximum of 25 stories. And the opinion provided in oral evidence was, I think the term used was that so the developers cannot, quote, break the density, unquote. You recall hearing that evidence?
Yes, I do.
And I'm just wondering if you can provide your reply evidence in relation to the evidence we heard from Mr. Lee in his oral testimony on those points.
Yes, Mr. Chairman, first, perhaps I'll deal with the height issue first. I think it's important to note that the approach that's being utilized in this plan is a flexible approach that incorporates built form policies in relation to height rather than prescribing a fixed height for a particular land area or quadrant. And it continues to be my opinion that that is the most appropriate approach for an intensification area, specifically the KDA here, to implement the level of intensification that's required. It still maintains the important requirements for compatibility and transition of height and context. And I think what's important is that its density is much more relevant in terms of control and more reflective of the amount or the capacity of development in a mixed use context, as it can be directly related to growth and the capacity for that growth. One thing I did want to recall is that I went back and looked at the November plan. And yes, the November plan, as we heard a lot of evidence on, had a set of prescribed heights. It also incorporated the ability to increase those heights and densities through Section 37. And so I am in no way suggesting that the additional heights and densities that may have been sought would lead to where the current plan allows for in built form, but it certainly was not fixed in terms of prescriptive height without that opportunity, which is now, as we know, translated into community benefits being collected through certain types of development, which certainly will be the forms of development implemented through this KDA. So again, I don't think it's appropriate to have a height maximum. I think as you've heard, considerable evidence, including my own, that the built form policy approach for this KDA is and should be implemented with the approval of the plan. If I can just speak generally to the concern about reducing the FSI, perhaps I can put it simply that we heard a lot about the number 110 and whether that was a size of an apartment that was used with certain assumptions to consider the number of units in the calculation in Appendix H. And I don't intend to go through any of that, save and except to say that that number was used in Appendix H to calculate consideration of a number of units. as part of the plan exercise. However, it was used as part of the assumptions, and even if used as a range, and identifying the lower end of numbers, which if you used a larger number would be higher. The implications of that are that we have a plan that has a resident and jobs number that, regardless of the size, would be maintained. And I think the most important thing in relation to any concern about the number of units going forward and reaching a threshold, which I believe Mr. Lee said was not appropriate because it didn't reflect what should have been a much higher number. The city itself has policies in the secondary plan that relate to monitoring. And it will monitor development, not in relation to an assumption that each unit is 110 square meters. It will monitor development in relation to the actual size, the number of bedrooms, the type of unit, the tenure of the unit, the size of the buildings, the non-residential GFA or commercial floor space. And it will track all of that as it is also considering developments that begin to reach that threshold. So it will have an accurate implementation through monitoring of all of those elements. Suffice it to say that the assumption of the size of a unit would not be applied going forward. It would be the actual types and size and number of bedrooms in units going forward that need to be tracked as well to ensure, again, the affordability targets are being met and the provisions as they relate to 3-bedroom units are being met. So it does not concern me, in my opinion, that the FSI is set at 4 overall. I think it's appropriate, and I think the holding policies and provisions will ensure that growth is adequately controlled.
Thank you. Ms. Anderson, you'll recall when Mr. Minette was testifying, we heard quite a bit of additional oral evidence from him on studies that have been completed and studies that haven't been completed in connection with the secondary plan. And he gave the oral opinion that in his view, one study that should have been completed as required in the Part 1 official plan was a study that identified constraints and opportunities. You recall that evidence?
Yes, I do.
And can you provide your reply evidence in relation to what we heard from Mr. Minette in his oral testimony on that point?
Yes. What I'd like to do is share with the members a copy of the Urban Strategies report. And this, just for reference, I'm going to share it on the screen, but the Urban Strategies background report is found at, where are we here? Volume 6, tab 20. And I will share it on the screen here. And Madam Chair, I wanted to share this with the members because I think it's an important study that was undertaken with the initiation of the KDA secondary plan work by Urban Strategies. And this concern that these constraints and opportunities were not considered or explored in the development and the formulation of the policies, I would respectfully disagree. And I referenced this study, and I'm going to go to, I think it's page, find my notes here, specific section in this report that deals with constraints and opportunities. I think it's in section, whoops, I've gone a little bit too far. I apologize, having to go so slowly. I think it's section 2.6. Whoops. Here we go, sorry, 3.2. So in this background report, this section deals with study area opportunities and constraints. And specifically, it's the culmination of background research that's been undertaken by the consultant. And I won't go through it in detail, only to note that it clearly identifies, and it has some narrative language. It also has some associated attachments or appendices related to some specific areas of constraint. And it speaks to opportunities. It speaks to the existing commercial uses. And I think the next page is actually a map that is actually very helpful, where it actually even specifically by site location starts to speak of some of these constraints and opportunities. And you'll see they're summarized at the bottom of the page here. But without going through them in detail, I wanted to emphasize that, this study did look at the opportunities of some of the existing commercial uses and functions that could serve the area as it intensifies, speaks specifically to the transit infrastructure and the planned transit investment. And it also specifically identifies the existing bus terminal. It also speaks to the large blocks or the large parcel sizes that are in single ownership as a great opportunity for consideration of redevelopment. And in addition, it speaks to the access to existing open space and surrounding natural areas and park areas. In terms of constraints, it identifies environmental constraints and actually has an appendices, A3, that specifically shows those environmental constraint areas. It also speaks to the challenge of, as much as it's an opportunity to have existing commercial uses, it speaks to the challenge of leases and the redevelopment and phasing in the area because of existing commercial uses. It speaks to the challenge of the transformation because this is predominantly a sort of a car-oriented, vehicle-dependent area, and the transformation to transit and more active forms of transportation. And then specifically, it speaks to a shallow aquifer and groundwater issues related to the water table, and actually has a schedule that relates to that. So I wanted to make it clear that in my review of the background information, and this issue came up in evidence, I thought it was important to provide this to the board to identify clearly that constraints and opportunities at this very early stage were identified and continued to be part of the context in considering the policies for the plan.
Anderson,
Sorry.
could I just ask what year this was prepared? I've forgotten. I'm sorry.
I believe it's November 2017. I'll just go. I don't think there's a date on the report, but it's referenced in the volume as 2017. Yes.
And just based on your review of this report, Ms. Anderson, do you have an opinion on the extent to which the analysis of opportunities and constraints does or does not remain current today?
Again, Mr. Chairman, the constraints and opportunities that have been identified continue to be relevant to the plan today.
Thank you. And turning then to the studies that have not been taken place yet, I think Mr. Minette referred specifically to 3, the stratification study we've already heard some about, a parking study, and an affordable housing study. And in his oral evidence, it was his opinion that all of that work should have been completed prior to the secondary plan being brought forward. Do you have an opinion with respect to what we heard from him in oral testimony on that point?
Yes, Mr. Chairman, I as with any study, there are a number of studies that are completed prior to, one of which I just referred you to, and that's the background report and constraints and opportunities study. It's not uncommon in a plan to have additional studies that are required to inform development going forward. And in fact, those additional studies that are underway to continue to inform the plan when completed may potentially result in a minor amendment to the plan, but will also inform the implementation of the plan. The stratification policies in particular will be the council approved policies should stratification come forward with development. But I did want to note that, it's common, and certainly from my experience in Oakville, as an example in North Oakville. That secondary plan for the North Oakville East area required a number of studies to be completed prior to any development taking place. It's a common practice in planning to have that. So to suggest that additional studies that inform the plan and need to be completed prior to implementing development is inappropriate, I would suggest is not the case. And I wanted to bring it to the board's attention that the city of Richmond Hill, in fact, in its secondary plans, has policies that specifically reference the requirements for required future studies. If I could just illustrate that by way of example, I'm just going to share, I can show both examples, but probably one is sufficient as they are both very similar. And I'll use the example from the North Leslie secondary plan, which I believe is secondary plan in section 9. And in section 984 of the North Leslie secondary plan, similar to, and that's not letting me go there. Does not want me to go there. Go to the bookmark. Okay, my apologies. I don't know why that doesn't work. Okay. It is. Oh, okay. That's not good. So perhaps I can come back to that. But the intention was to indicate that in both the secondary plans that are provided for, there is a section that refers to additional required studies, and it notes that those additional required studies, and it specifies the requirements should be provided prior to development going forward in those secondary plans.
And Ms. Anderson, perhaps you could just provide for reference the section numbers in each of the two secondary plans that you were referring to?
Yes. In the North Leslie plan, it's section 9.8.4. And in the West Gormley secondary plan, it's section 8.8.4.
Could I just ask, do they require individual or whatever studies for each development application that comes forward? Is there a general, thou should have these studies in place before any development is applied for?
Madam Chair, I believe it's generally.
Did you have anything further on the requirement for a stratification study other than your comments on the actual policy that we heard a little earlier?
Yes, I did want to note in terms of stratification, in addition to the reply evidence I provided related to Mr. Minette's position that the stratification endorsed policy is not required and it's not appropriate to provide that. I wanted to note that, in fact, again, it's not uncommon in plans to have a particular reference to a council endorsed policy that is required in relation to a particular policy element or area. And in thinking about this, I noted in part 1 of the official plan for the city. And again, I'm not sure, am I sharing my screen? Did I stop? And I believe this section is here. So and I just wanted to note as an example, section 5.2.3. And again, this is a policy that relates to the MESP. And the policy itself at the bottom here, you can see that it says an MESP shall be prepared on the basis of subwatersheds and shall have regard. And it goes on to talk about what is required, but it basically requires that the MASP is prepared based on a council approved, and it refers to a terms of reference. So it's clear in the plan that terms of reference for a scope of a study is something that has to be in place in order for the study to go forward. So similar to the requirements in the plan for complete applications that reference terms, approved terms of reference by council, those have to be in place and are referenced in the plan appropriately so that anyone utilizing the plan and looking at, so what are the terms of reference requirements? Those have to be approved by council. What are the stratification policy requirements? Clearly in the KDA, those have to be approved by council. So this was by way of illustrating to the LPAT members that it is within the current city official plan to have reference to council endorsed policies.
Thank you, Ms. Anderson. Through the examination of previous witnesses, you'll recall that there was some uncertainty about the timing or status of the various studies and updates that are relevant to this secondary plan exercise. And I'm wondering, just for the assistance of the tribunal, if you can provide any purely factual information as to the current status of those policies, of those studies, I should say. My apologies.
Yes, for the assistance to the tribunal, there has been mention of a number of studies and references in terms of the City of Richmond Hill official plan update. That update was initiated in November of 2019. It was originally to be completed within 6 months of the region's municipal comprehensive review. And so originally anticipated to be adopted sometime in 2022, given the timing. And really now it depends on how much the region can get done in the context of COVID and also the recent growth plan amendment. So we know with official plan reviews and MCR work, the timeframes change. And certainly given the impact of COVID, some of the timing for the consultation has been extended. And then specifically with respect to the region's official plan review and the municipal comprehensive review started quite some time ago in 2015. That was put on hold when the province did its coordinated review and certainly restarted. And then with some further setbacks in relation to the growth plan amendments with Schedule 3, and now with the most recent amendment to the growth plan pushing out the growth forecast to 2051. And so that work is ongoing, but as we saw as recent as, I think last week, the region provided an updated draft in relation to the MTSA boundaries and density. So again, ongoing work at the regional level. There's been reference to the Richmond Hill Center study, and this is the Urban Growth Center, and that work started early in 2019. That timing was impacted by some of the changes to the transportation infrastructure, specifically the Yonge North subway expansion, and certainly COVID has had some impact again on the city's ability to undertake some of the consultation work. And the secondary plan is expected to be completed and be in tandem with the update to the OP. The Yonge and 16th Avenue KDA, we heard reference to that in terms of a draft of the secondary plan, and the zoning bylaw was actually presented in 2018. And council had directed that there be more engagement with stakeholders on that, and also coordinating with the OP update, and staff have decided to do a more detailed plan and are proceeding with that. No change in relation to the transportation master plan or the updates to the master environmental servicing plan. That's work had started, but again was being aligned with the new OP work, and also the changes to wait for the regional allocation of growth as it would relate specifically to the transportation master plan. And certainly we've heard a lot about the parking strategy, and you heard factual information from Mr. Chervevsky in relation to that work being underway. And again, it's citywide, and some challenges again related to COVID in terms of some of the technical work that has to be undertaken. But that work is certainly well underway. And finally, in relation to the stratification study, that work has actually commenced with a draft terms of reference, and it's intended to be completed by the end of December with a work program that's been set out in that terms of reference. So hopefully that assists the board, just a general overview of all of those different plans and policies as they're proceeding in the context of this KDA and this hearing.
Just from an overall standpoint, Ms. Anderson, can you indicate to the tribunal to what extent your current understanding of the status and timing of these studies, to what extent that has a bearing one way or the other on the opinion you've previously given respecting the appropriateness of proceeding with approval of the secondary plan at this point?
Yes, as I had reinforced in my evidence, I think it is appropriate, given those ongoing studies are not required to approve and implement this secondary plan. And in fact, it's appropriate to respond to the current and evolving provincial and regional policy requirements to apply the requirements for intensification within this plan. And that does not need to, in essence, wait for these other plans and policies to be in place in order for it to be approved and to commence with implementation. In fact, I think it's appropriate to proceed with it in the short term, so that those who are waiting to implement their developments can do so in a timely and comprehensive way.
Thank you. And lastly, Ms. Anderson, you recall it was put to, I believe, a number of previous witnesses that in relation to the evidence that was heard by the tribunal from the other professional planning witnesses who testified, that they only spoke to their specific clients' properties and did not, in fact, support or adopt your opinions with respect to the secondary plan and zoning bylaw on a KDA-wide basis. Do you have any evidence to provide in reply to that suggestion that was put to previous witnesses?
Yes, certainly my evidence has addressed the broadest elements of the plan and the zoning bylaw. But it was suggested that the other planners were only providing evidence as it related to their specific clients' lands. And without the opportunity to go back and review the evidence of some of the planners based on my being recused from the hearing at that part, I did go back and look at their actual witness statements. And specifically their reply witness statements. As I had noted, I had recalled reviewing Mr. Falletta in particular, his reply witness statement that specifically referenced my evidence in relation to the whole plan and adopted my opinion. And that is actually, just for reference, in Mr. Falletta's reply witness statement, which I believe is Exhibit 43. And Mr. Falletta, you will recall, is the planner for, I think it's 10870 Yonge Street. And he had specifically indicated in his witness statement that he had reviewed my witness statement, and this is in his reply, and adopted the opinions and concurred with the opinions overall that the entire KDA and secondary, the overall KDA secondary plan and zoning bylaw as modified should be approved.
Mr. Chair, I've had to think about this for a moment, but the witness is referring to reply witness statements that she had when she was giving her direct evidence. So I don't know why she needs to refer to them now in reply.
Mr. Chair, I think she's referring to them in reference to the proposition that I believe Mr. Streisfield put to previous witnesses, suggesting that none of those other planners, in fact, adopted or supported Ms. Anderson's evidence on a KDA-wide basis. So in my submission, what you're hearing from her is in direct reply to that proposition put to previous witnesses.
I guess the problem with that is that if we pull up the cross-examination of Mr. Filletta, it's very clear that he was only confining his opinions to his own lens. So if you were just looking at the witness statements or whatever, you have to look at the video. And I think it's very clear. I'm happy to pull it up, but we'll just move on.
In my
I'm happy to
submission,
pull it
Mr. Chair, that's a matter for closing submissions. This witness is giving her evidence. My friend is free to refer to evidence in his, either on cross or as part of his closing submissions.
Why not? Go. Oh, sorry. Go ahead.
And Mr. Chairman, the only other note I would make is similarly in his reply witness statement, Mr. Lincoln Lowe offered his overall support for the plan as modified, and that's found in his reply witness statement, which is Exhibit 32, and it's actually in the first 2 or 3 points.
Mr. Chair, that would have completed my evidence in chief of Ms. Anderson on reply. However, it's been brought to my attention through Mr. Kahar that one of the policies that we thought had been settled amongst the parties, that's noted in Exhibit 74, a number of parties have in fact raised some concern about it. So my suggestion is, before we go into cross-examination, perhaps we could take a break right now for 10 or 15 minutes. It'll give us an opportunity to consult with the counsel who had raised a concern. And then I can just briefly finish up with Ms. Anderson on that one point.
Not being heard because I can't find any of my.
You're fine.
Nothing on my screen at all. We'll take a break for 15 minutes then. Okay.
Thank you.
Why do I have to